Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about alien smuggling, what it is, when one may be found guilty of it, convicted, or found to have committed it, how it affects one's immigration situation in the United States. So first of all, let's start with the definition of alien smuggling. What is it? Some people mistakenly believe that alien smuggling is actually the act of transporting somebody through the United States border. But it's more than that, unfortunately. The definition, if to be precise, says that any person who knowingly has encouraged, induced, assisted, abetted, or aided any other person to enter or try to enter the United States illegally would be found to be an alien smuggler. So these provisions are very broad. Usually we're dealing with a common scenario when a family member is trying to help another family member to come to the United States, perhaps by giving them money and funding trip, by paying coyote, by providing some false documents, for example. So one can be found inadmissible based on alien smuggling, can be found deportable based on alien smuggling, and found to lack good moral character, necessary, for example, for naturalization, cancellation of removal, self-petitioning under Violence Against Women Act. So it has drastic consequences. The good thing is that with time the law developed limiting liability somewhat for certain people. For example, it was held that the smuggling has to be affirmative and the person has to act knowingly that they do something, that the person who they're transporting, who they're helping to move or come, in fact, entering illegally. Okay, so there are various examples about that, but the point is that before you're going to make any plans for someone to come to the United States, think about it. Okay, the consequences can be drastic. Now, that I have to add here that smuggling is different from harboring and transporting. Even though sometimes smuggling can be found even if you assist someone in the United States already, okay? Even if somebody is in the United States and you continue helping them moving through the United States, that can be smuggling as well. There are various examples, usually from the federal courts, meaning that they're available for search. So public search, or let's say via Google, you can read more about that if you have any concerns. In my experience, this issue currently comes up with criminal convictions or with special immigrant juvenile cases and I-601A waivers at times, okay? What happens is that very often those children who are crossing the border are doing so with the help of one of the parents, okay, one of their parents. And that parent may be charged with alien smuggling because they're transporting someone else, even though they're themselves crossing the border. At times, this issue may come up in connection with I-601A waiver when people are writing affidavits about how they came about to the United States, who helped them. Maybe someone else shared information about the person, and the consul may charge the person who is filing for I-601A waiver. Basically, the waiver was approved, and then now the person is at the interview in the consulate of the United States in their home country. This issue comes up. It says, well, we have information that, or you admitted actually transporting somebody through the border, you helped your little sister or something like this, right? So these are the common scenarios. And of course, at times people simply get caught transporting somebody at the border and they're charged and they have a criminal conviction. I have to say here that criminal conviction under a state statute not necessarily will also be an alien smuggling aggravated felony. but a conviction on the federal statute of alien smuggling will be an aggravated felony, and that has its own very drastic consequences, as you may be aware. Good news. Is there any good news here? Yes, the good news is there is a waiver available, very limited waiver. And when we just talk about the waiver, as you may be aware, there are grounds of inadmissibility, deportability. So right now we're talking about the ground of inadmissibility is when somebody is seeking admission to come to the United States. It either can be a lawful permanent resident after the travel abroad, or only one other situation is when a person who is in the United States, let's say, seeking adjustment of status or seeking an immigrant visa based on a family petition only. Okay, family petition only, and that petition has to be in a first, second, third preference category or immediate relative, but not in a fourth. Meaning that when a brother or sister sponsored a brother and a sister, and let's say the consulate, the person was found to be inadmissible based on alien smuggling, the person will not be able to file for the waiver in this particular situation. The person has to be sponsored by, let's say, a parent or a spouse. Maybe, yeah, parent or spouse, maybe child. Okay. All right, so alien smuggling waiver. Let's talk about it. It's available only, as I said, for certain applicants. Plus, the person who was smuggled must be spouse, parent, son or daughter. No one else. Spouse, parent, son or daughter. And it incorporates child. Son or daughter is above 21 years old. Child is below 21 years old. So if you tried to smuggle your friend, your grandma, your fiance, nephew, uncle, you will not be able to get the waiver. Okay, only if you try to smuggle spouse, parent, son, or daughter. And then the government is going to look at presence of humanitarian purpose for granting you a waiver, to if there is an issue of family unity and public interest. Basically, you still have to show that you're a rehabilitated, good person, that somebody is going to suffer hardship in case of your close family member, in case of your inability to get the immigrant visa or adjustment of status. But that's the situation. The waiver is very limited, even though it's available. Now, there are some applications that one would file based not on a family petition that still may be able to apply for a waiver. It's a different type of waiver, but it basically incorporates all different grounds of inadmissibility, including alien smuggling. That is when one is filing for U visa, T visa, perhaps S visa, VAWA cases, asylum, refugee adjustment. Okay, those people, those filers have their own set of waivers available, very broad waivers that may waive this ground. Of course, you also have to be careful about that, because in certain particular situations, you don't want to be charged with a separate ground of deportability depending on your situation. Usually, this unknown issue of whether you should file for something or you shouldn't, when there is no waiver available, arises when you have to prove good moral character. Let's say you have to file for citizenship, but somewhere far in your record you had the issue of alien smuggling. Shall you file or shall you not? Usually they look at the statutory period for the good moral character, 5 years, but may look at the entire period in the United States, right? So that's going to be a tough call for you to make with your attorney, whether you should or you shouldn't act when you have to file for something requiring good moral character and you have this alien smuggling in your record. So when it can be a separate ground for deportability, you should be careful. Now, there is also a waiver. First of all, when can it be a ground for deportability, alien smuggling? It's narrow, more narrow than ground of inadmissibility. So someone may be found deportable based on alien smuggling when they committed it before, during, or within 5 years of entry. Okay, so it's more narrow. There is a time limitation as to when it can become a problem. That's a good news, right? Bad news, of course, for the good moral character determination. Terrible news if you also were convicted of an aggravated felony, because then, of course, you're permanently barred from establishing good moral character for naturalization purposes. You're deportable with no apparent waivers. There are very limited situations when permission to come back can be granted. Of course, there is a non-immigrant waiver available that waives almost all grounds of inadmissibility, but we're talking about permanent solutions here. So bottom line, alien smuggling is kind of broad, but not as broad as some may think. All right, so it does need to have elements of affirmative act and acting knowingly. There are waivers available for inadmissibility and deportability, time limitations for deportability, and basically it's something that you need to be aware of when you're filing for immigration benefits. And remember about admissions. Admissions and information that that can be found in your file, especially in connection with special immigrant juvenile cases. I hope you enjoyed this video, and if you're looking for more information on immigration and various topics, please visit our website www.shautsova.com, and I hope you liked it. Please subscribe and share our videos. Thank you.